recognizes himself for 5 minutes. Director Chopra, let me start with your policy statement defining abusive acts or practices. Do you believe that financial services companies should be held liable for not complying with novel guidance or regulations that you have only recently published on a retroactive basis?
No, and in fact, the abusive policy statement, which really was an attempt to try and avoid situations where people didn't know.
Yeah, no, and I appreciate that, and you've said that before in this committee. I do appreciate that. So can I take it from your testimony that your policy statement will only apply prospectively?
Well, the issue is that the statute, though, has always existed. But
Okay, fair enough, fair enough. Reclaiming my time, I am generally glad to hear what you just said because I don't think it's fair to punish companies for operating within the boundaries of the law at the time the company was engaged in an act or practice that was lawful at the time, even under the pre-existing statute. I do, however, plan to introduce a bill that ensures that the Bureau does just that and does not try to retroactively apply new requirements onto activities that occurred in the past. And I would appreciate your input on that and working with me on that legislation to make sure that we're achieving our mutual goal.
And you know I want this to be durable and not ping pong.
Right,
and
great.
Not, sorry. Yeah.
Great. 1071. Director Chopra, if a small business begins a loan application process, can a lender under your 1071 proposal disclose to them that they are required to collect information under the direction of the federal government?
I need to look at the specific regulation, but my understanding is that even the model form makes very clear that this is a government requirement.
Okay. Yeah. Does a small business loan applicant have the right to refuse to provide this data under your proposal?
Yes. It's actually not under the proposal, it's in the statute.
Great, great. I agree, it is in the statute. And so under 1071 and under the statute, small businesses are not legally obligated to provide data in connection with any application of credit. But do you believe a small business owner should know why an institution, before any underwriting occurs, is collecting demographic information about them?
If I understand your question, I think, yes, that's right. And in the Home Mortgage Disclosure Act, I believe also there's a similar type framework.
Okay.
I need to check.
Well, do you recognize that if a small business owner fails to understand why the data is being collected, it could lead to confusion and misunderstanding and potential liability for a financial institution? In other words, if they're asked to disclose their race or their ethnicity or their LGBT status before underwriting occurs, and then that loan application is denied, that could lead to confusion as to the basis for the denial of the application. You understand that?
I understand that.
Yeah, and so based on your response, I believe you would agree with me that providing a simple document to consumers or small business owners explaining all of this would help clear up confusion in the small business lending space. And Chairman, I'm asking myself for unanimous consent to submit for the record a potential questionnaire crafted by the Kentucky Bankers Association that would do just that without objection. Dr. Chopra, my constituents who provide small business loans in my district in Kentucky tell me the 1071 rule would force them to exit small business lending and will therefore decrease availability and increase the cost of credit for small street borrowers. I believe this questionnaire could help clarify the need for, or the lack of any need for, this data collection effort and reduce incentives for firms to exit the market because of fear of legal repercussions. Question, Director Chopra.
By the way, I'm very open to that.
Okay, I'll share with you, and I appreciate your feedback. Final question is about funding in the Supreme Court and what the Supreme Court is ready to do. Did you see that the FY24 Financial Services General Government Appropriations Bill that we just took up in the Congress, that the Congress funded the CFPB in that bill at current levels? Did you notice that?
I did.
And did you notice that Republicans, the Republican majority with Democrats, voted down an amendment that zeroed out the CFPB's funding?
I didn't catch that, but your colleague mentioned it.
Yeah, so, I mean, clearly some Republicans voted to zero it out, but that amendment failed. I want you to take notice of that. And I want the Supreme Court to take notice of that because it demonstrates that the Congress is not about eliminating consumer protection or the Bureau. It is about upholding the Constitution and the separation of powers. And if our bill were enacted, the agency would continue to operate. The only difference would be that Congress would oversee the agency's spending in the same way it does for most other consumer protection agencies. And I believe it's time for Congress to regain its most important oversight tool, and that is the power of the purse. And with that,